You're listening to the Valley Current.
The challenges facing the whistleblower are potentially huge. I think one thing that would be good is just to give the whistleblower a checkbox and say, I'd like the proceeds of any compensation to go to an eligible charity.
Does the whistleblower get to make that decision?
Well, right now it's a cloud of uncertainty as to whether the whistleblower would be taxed on the award prior to any charitable donation, or whether they could somehow completely exclude themselves from liability of any kind by just electing to forego compensation and give everything to a charity. And I'd love to see some sort of legislation inside these programs that allows the whistleblower to be fully protected from a potential large tax bill just by opting to give the any proceeds to a reasonable charitable cause.
So in general, has your counsel, I guess technically the law firm was your counsel as the lead class representative, do they take any of these suggestions and do anything with them, or the reality is that's just not within the scope of their representation? They don't think about how the system can be improved, even though they're obviously playing a role in the system, because that's probably all they do is class action cases, right?
Yes, they do specialize in class action cases, and no, they are not able to give tax advice that's outside their scope of practice, nor are they legislating for changes in whistleblower options, advice, counsel, or protection. I was thrilled with what was my representation. I thought they went above, even when a judgment or a change or a positive outcome was very remote. They still put a lot of hours and expertise into this. So I would highly recommend them.
I mean, a lot of it was like huge data crunching, right? Because they had to take large volumes of applicant data and compare it to what was actually turned into job offers, right? That sort of thing.
Yes, there was a large electronic component to it. And there were several precedent-setting motions. There was a lot of motion practice with over 300 filings. I'm sure the filings would, if printed and put in a stack, would be at least 10 feet high. And there was one circuit split. So the Judge Tigar decided that ADEA applies to applicants, not just to existing employees in the Ninth Circuit covering most of the West Coast, but older workers older applicants experiencing age discrimination in the rest of the country are reliant on state law, which is very patchwork in terms of who is protected and who is not protected. At least that's my understanding as a non-lawyer.
I mean, this is actually on Google. I just typed Steve Rabin class action case on Google. Comes up as PwC age discrimination lawsuit. That's the first entry. That I guess this is done maybe by the law firm. It's hard to figure out who's the actual publisher. It says pwcagecase.com. This is all public information. On March 3, plaintiffs Steve Rabin and John Chapman and defendant PricewaterhouseCoopers filed a proposed class and collective action settlement with the court. On August 19th, 2020, the court preliminarily approved the settlement, which requires PwC to pay $11,625,000 and implement various elements of programmatic relief. And then there's a bunch of stuff about what followed. I could put it on the screen, but I'm sure you're very familiar with this. I'm guessing this is a publication not of PwC, but more of the law firm or whoever was running the disclosures, or whoever was running the publication of how this thing is supposed to ultimately get distributed across all the applicants, who I assume have to have to follow up in some way? I'm just guessing
Yeah,
at this
yes.
point.
The website was created to find and encourage other people who potentially had experienced discrimination. It's finding a lawyer to represent us in the first place was a very challenging process. I spoke with about a dozen law firms before finding one who was willing to take this case on. And then the discovery process was substantial. We found 20,000 other accountants who had experienced roughly similar, and that number is approximately 20,000 other candidates who experienced roughly similar discrimination. And we sent out 20,000 postcards. And of those 20,000, roughly 5,000 nationwide decided to join the class and collective action. I'm not sure why it's called a class and collective, but
I think the state law provisions end up referring to it as a collective action under state law.
In at least some of the states, yes. And
Right.
then there was a complex formula based on what state you lived in, whether you had a CPA license, and possibly a few other considerations as to who got what share. And then an outside firm that specializes in class action settlements was contracted to distribute the settlement money and checks and issue the 1099s and W-2s.
And why was the date March 10 of 2021, essentially about 3 years ago, to June 10, 2022, essentially what sounds like a 15-month period? Did they change their practices?
The practice changes kicked in at the end of that period. That's my recollection, and lasted for 2 years. But that extended period was really designed to allow this outside settlement firm to qualify the 5,000 members of the class and collective to make sure that people were who they said they were, and that the formula was being calculated accurately, that each person should get so many $100. So it was really an administrative delay. It also presumably allowed the court to do any final approvals that might be needed to make sure that everything was on the up and up.
So did this affect PwC's retirement policy too? Because I thought they had some mandatory retirement at 60 or 60 something years old.
I believe that they do, but no, that aspect was not included because the retirement of partners, well, partners are not considered employees. And my litigation was limited to admission of new, relatively junior level applicants for employee positions only. So partners were not covered by this. I imagine that if partners had been included in the case, that the dollar amounts would have been much, much larger.
Right. I mean, just looking at the lawsuit that was filed on the PACER system back in 2016, April 27, 2016. So we're talking really, as you said, 8 years ago next month. And it shows 4 different law firms or groups, one of which is this AARP Foundation litigation. And I assume in addition to the 11 million, I assume there must have been a separate request for attorney's fees as well, right?
I think that the attorney fees were part of the 11 million, and that that's a big part of why nobody received any large chunks of money. The changes in process that the defendant agreed to were valued at perhaps another 10 million. But that wasn't a cash amount. That was just somebody's estimate of the cost of changing their policies and practices.
Wow.
So, we're not talking huge amounts of money. If this had gone on to trial, then it would potentially go on to appeal and from after appeal, potentially go on to the Supreme Court, which recently has had some controversial color or bias.
But it sounds like you did. It sounds like you had a pretty solid case on the facts. The law maybe is more uncertain, but the facts sound like they were engaged in the discrimination that you were claiming. I suppose they denied any admission of liability, but they made changes, so you got the policy changes all to occur, which is a big feather in your cap. I don't know what it means in terms of people ever sort of asking you, are you a litigious guy or something like that? That's probably the only lawsuit that you've ever been involved in. I'm kind of curious at this point. I didn't do a broader search to see if there's other stuff out there. But you learned a lot about federal class action litigation as a result, right?
I did. If you did a thorough search, you might find a class action or two against car dealers or tenants or whatnot. But at each stage of appeal, you're rolling the dice, and there's a good chance that you'll lose on a technicality, even if you were justified in your overall case. I'd like to go back to finding a lawyer, which is something that I imagine a lot of our listeners sometimes face in their life, and the challenges of trying to find a good lawyer, because lawyers are very specialized. Mm-hmm. And they, as you know, you guys, I should say you and not they, being a lawyer yourself, an excellent lawyer yourself, but you will eventually find a set of cases, a set of fields or industries in which you can practice efficiently, and taking cases outside of your field would not serve you or your client. And so to try and find a good lawyer was a huge struggle for me. I tried to get some referrals, and that wasn't working. Eventually, what I did is I started doing a Google Scholar to try and find firms that were litigating against the same class of defendants. And I found a small firm that was called the Liu Law Firm, Jennifer Liu, Liu. And she had just written an article about her litigation against another Big Four. And I figured that if she and her resources and her, her resource base was able to take on a Big Four over wage and labor rules, that they might be able to at least recommend somebody to take on my case. And so she was willing to meet. I was thrilled. I met with her. She said, I'll take it, and write me a check for $400 retainer, I think it was. And I was thrilled to give her the $400 and have an actual attorney on my side.
Right.
But again, it took a dozen lawyers to find her. She's now got her own firm called the Liu Law Firm. But at the time, she was a mid-level attorney at a firm called Outen Golden. And that firm was my attorney in this case. And the San Francisco partner was named Jahan Sagafi, and which is a Persian name. He was a brilliant and dedicated representative, and he has helped many other people, employees and applicants who've experienced similar problems. And I would highly recommend both him and his firm, Outen Golden.
Well, congratulations, Steve, if you are telling listeners that there are resources available ultimately on a contingent fee. I guess you did spend $400 and probably a lot of your time, 1,000 hours of your time or somewhere near that times whatever your hourly rate is not a trivial amount. But sometimes justice can be obtained. The wheels turn slowly. 8 years later, you're finally to finality and final resolution. So congratulations. It's good to hear the story. And ultimately, I think the other lesson is when Congress changes legislation, they should interview people like you because you have brilliant ideas about how to improve the system. And yet they don't really do the kind of interviewing. They could have randomly sampled 100 class representatives, and I bet they would have gotten 100 really good inputs on how to improve the legislation, which they do put a lot of people, a lot of congressional staff on this work, but they don't necessarily produce the best results in terms of the output, as you're noting in your comments on the legislation that just passed. So thanks for that as well.
There's also, if you're contemplating this path, be sure that it's really worth it to you. You probably will not get a financially rewarding outcome, but you may be able to change the world slightly.
Well, changing the world is worth a lot. So thanks, Steve, for doing it. We'll connect again later this month. I appreciate your time.
Likewise. Thank you for having me on.
Tune in next time on The Valley Current.